Good evening and welcome to Reasonable Doubt, a show about pending legal issues of interest to the Houston community. I'm Pat McCann. I'm your guest host this evening, filling in for Rob Fickman, who's spending time with family this week. Tonight our topic is about the anatomy of a wrongful conviction, how they happen, why they happen, and what we can do about them. My guest this evening is a seasoned criminal defense lawyer from the Houston area, Norm Silverman, who's experienced this firsthand. Norm, thanks for coming in this evening.
Pat, thank you. Let's jump right in and get started, because this is a hot topic near and dear to all of our hearts in the criminal defense community, and I think important to everyone, because this is a subject that can happen not only to people legitimately accused of crime, but to people that are completely innocent. And I think it's all of our worst nightmare.
I agree, and I wanted to talk to you about this. The way that we see this happen in the news, for instance, we've all seen stories about the HPD crime lab's mistakes. We've seen stories about, recently from San Antonio, about a fellow who was wrongfully executed. At least that seems to be where the evidence is leading, that a coerced statement by another man put him behind bars and gave him a death sentence.
Well, let's talk about that for a second. That's a good first area to start in. I think there are certain areas that I've noticed in my career as a criminal defense lawyer that give rise to questionable convictions and possibly even completely wrongful convictions. And one of those is the police practice, which is completely legal under our law, of using trickery and deceit to obtain confessions, not just confessions from the accused himself, but also from co-actors that might implicate the accused.
Let's talk about that. A person is brought in accused of a very serious crime, aggravated robbery, even murder.
Yep.
And they are brought in initially, typically by a detective who's working the case with another detective, and they are placed in a room very similar to this. They're recorded sometimes, sometimes not. Depends on how much they want to talk to him a little bit beforehand.
Yep, got to get them warmed up.
And when they talk to him, there's no lawyer present for that fellow.
Absolutely not, unless the accused is smart enough to invoke their right to counsel. Because the minute a person invokes their right to counsel, it's like magic, or at least it's supposed to be. And it cuts off all further questioning by the police. And it's the nature and quality of police questioning that I think is of particular importance here. Let's talk for a second about what is legal under our law with respect to the use of trickery and deceit to obtain statements from an accused person.
Let's give an example. We all know that, for instance, beating, I would hope we would know, that beating a confession out of someone is not only wrong, but it would make the confession inadmissible, provided it was proved up in a court that that's how it got to be.
Certainly, it would make it an involuntary confession. However, if two guys are brought in together, Johnny and Jimmy, they can be separated, placed in separate rooms. Johnny can be told that if he wants to help himself, he really needs to tell the truth about what Jimmy has done. And he also will be informed that Jimmy is already in another room laying full blame for whatever criminal incident occurred on Johnny, on himself, on the other accused person. And you can see how when this sort of practice is perpetuated over hours and hours and hours in a room like this one, a dark room or a closed, confined space, that even that almost anybody would be subject to hoping to gain some leniency when it seems that all the tables have been turned against them, even though they're innocent.
And let's talk about that as well. Let's be honest, every one of us is vulnerable in some way, whether we have a relative, a spouse, a child who may have had a run-in with the law. Every one of us may have some fear of something coming out.
Some little skeleton in the closet.
And if that were used against us, how do you feel about the voluntariness of any statement that comes out again?
Well, of course, it depends on how it's used and the facts of a given case. But I take issue with the common practice and the legally condoned practice of lying to people accused of crimes, lying to them and telling them that their cohorts are implicating them to gain leniency with the authorities, and that if they want the same favorable treatment, they need to implicate their co-actors. You can see how this leads to a result that is less than reliable.
Now, there actually is, in legal terms, an instruction to juries called accomplice witness testimony.
Correct.
Which means that if someone who is an accused co-defendant, a co-actor, in a case, is going to testify against me, let's say, in a drug conspiracy or a murder, that there has to be something beyond that person's testimony linking me to the crime. Can you talk about how that comes about?
Well, certainly in state court here in the state of Texas, that is the law. No person can be convicted on the uncorroborated testimony of an accomplice witness. And an accomplice witness is someone simply that could be accused or convicted of the same crime for which the accused person is on trial. The thing is that is a law that I can't say with certainty that that is unique to Texas, but I will tell you that in the federal system, you do not receive an instruction to the jury informing them that no person can be convicted on that kind of testimony. Rather, you receive a cautionary instruction, instructing the jury that they should proceed with great caution with that type of evidence. And then in state court in Texas, the degree of corroboration required is rather slight, and I think not significant enough to lend reliability to a process that's inherently unreliable.
So really, in federal court, for instance, a drug case may come up and a person may be convicted upon the testimony of a co-defendant. The jury is instructed to weigh the fact that they are a co-defendant and could be charged for this and may have a reason to lie, but it doesn't prohibit it from going forward.
That's exactly right, and that's the exact same circumstance that exists with our second category of events that are likely to lead to an unreliable conviction, and that is jailhouse informers, snitches.
Let's talk about that. I can speak from some experience on one of those cases where I was involved, where an individual was we believed, solicited by the staff of a jail here locally, and that individual was then encouraged to obtain statements and to lie about those statements on the stand against another individual that he was in jail with.
Now, did the prosecution participate in this encouraging to lie?
As far as we could tell, they did not know. The problem is that it's not, the prosecution gets given information from the police.
Well, when I say prosecution, I'm including the police, the prosecutors, anyone involved on the state side, because that's what our law is. That the prosecution team is the prosecution team, and if anyone violates any of the rules, the bad result is attributable to all of the team.
Well, and I think that's an important thing to focus on, that there are times when, for instance, one part of the team may not be telling the other part of the team the truth.
Certainly.
And certainly if a police officer goes over the line, he has really no incentive to tell the prosecution, gee, I really messed up here. I'm sorry. We should let this fellow go. That's not going to happen in the real world.
No, I mean, I think that people rationalize their misconduct, and they think to themselves. I think that policemen trying to obtain confessions, or prosecutors or policemen talking to jailhouse informers, have a certain version of the facts that they themselves believe to be true. And if they can corroborate that version through this other person that's talking to them, they're going to give reinforcement to that person in a very subtle way. And sometimes these little white lies, or this little cue of you're on the right track, can lead to the most egregious form of injustice, a wrongful conviction.
Now let's put this in some perspective though as well. There are times when, and many criminal defense lawyers have experienced this, when, for instance, a client will speak,
run his mouth foolishly in the jail.
Unwisely.
Absolutely.
And in fairness, isn't it fair to ask if the state should not be able to use those statements?
Certainly. I would think that would be abundantly fair to use those statements. The issue, the place where I take issue with this is, if we as defense lawyers were to go to jail and seek out witnesses that would provide exculpatory evidence evidence that tended to prove that the accused person was innocent. And in seeking out these people, we were to make offers to them. We will reduce the amount of time that you have to spend in jail if you will speak favorably of my Johnny or my Jimmy, whoever it is that I'm representing. We would be indicted in a heartbeat, probably both on the state side and the federal side. If we offered money to these people, we would be the most reprehensible form of injustice-forming criminal. But when the prosecution does the same thing, Pat, there's no penalty. There's no price to pay for that.
Let's talk about that for a second. I think many people underestimate the enormous power that a prosecutor has in their discretion to bring a charge, to elevate a charge, to continue with a charge, or reduce a charge, or dismiss a charge. It's called prosecutorial discretion. And when we look at this from the outside, it seems reasonable that a well-informed, well-intentioned prosecutor should be able to decide what the appropriate charge should be. In the wrong hands, let's talk about how that can go horribly awry.
Well, as I said, I think that given the human tendency to rationalize, what looks like a little bit of suppressing exculpatory evidence, because you see, as we all know, the prosecution has a duty to disclose to the defense any evidence which tends to show that the accused person is innocent or is in fact not guilty of the charges against them. And so the question then becomes well, what is really meant by exculpatory evidence? Is it exculpatory if one of our witnesses has some baggage that we're just going to withhold from the defense to prevent them from using to impeach the witness? Is it exculpatory that a witness has a history of drug abuse? Is it exculpatory that a prosecution witness has a history of embellishing facts or a history of a mental illness or something that would make them less than an accurate reporter of the facts? Is it exculpatory that someone was promised a certain reduction in the amount of time they would have to serve in exchange for their testimony? And you can see how when you're a human being with an agenda, and that agenda is a prosecution agenda of winning convictions, you can see how the human tendency to rationalize could make something that ultimately turns out to be an egregious mistake into just a little white lie at the time that it's first perpetuated.
And let's also not underestimate the fact that, for instance, in the federal system, where the sentencing laws up until recently were very, very harsh.
Well, they still are, for that matter.
And there's been some relief, but you're right, they're still very tough. A person could be looking at an enormous sentence on a very simple drug possession. Their whole life is essentially in the balance of what they decide to do, their children's life, their ability to be with their spouse for the next 20 or 30 years. It's an enormous incentive to lie.
Well, in my opinion, the entire federal system is nothing more than legalized bribery. Now, when the federal sentencing guidelines first were put into effect, the idea was to make sentences more uniform, so that we wouldn't have a judge in New York City sentencing someone to X amount of time, a judge in Houston, Texas sentencing someone on the same facts with the same criminal history to more or less time. We wanted to create uniformity across the board, and the reason we wanted to do that was to make the sentencing predictable, so that a person could say to themselves, if I engage in this level of criminal conduct, these are the consequences that I'm going to have to face. And instead what's happened is there's no predictability, because you don't know how the evidence is going to be viewed, what evidence is going to be credited, and what evidence is going to be discredited by that particular fact finder or judge. We've created more unpredictability in sentencing ever since the guidelines existed, and I understand that they are now merely advisory in light of recent developments of the law, but my experience has been that most judges still rely on them to a great degree to determine what a fair sentence is for the conduct involved.
You mentioned unpredictability, and I think that's an important factor to bring in here. As someone we both know has just mentioned, that anytime there are human beings involved in a system, there are going to be mistakes. But let's talk about our side of the bar for a second, and let's be candid. There are plenty of defense mistakes to go around that contribute to a wrongful conviction.
Absolutely. I think at one time or another, anybody that does this job is going to be ineffective. They're going to be guilty of providing deficient performance, of failing to interview a witness, of failing to subpoena a witness and then having the witness leave the jurisdiction to where they now become unavailable, of focusing on one case to the exclusion of another. This is a very high stress, high pressure business. And the most we can ask for among our colleagues, I think, is when you do screw up, to be candid and admit it.
Now, ironically, though, the Texas legislature just passed a rule that, at least in terms of a capital context, capital crimes, is going to prevent that kind of honest disclosure by our side of the bar.
How's that, Pat?
Well, what they're saying is that if someone is found to be ineffective on any case, then they are removed from the appointments list for capital cases in whatever county they happen to practice.
Well, we have that rule in all cases here in Harris County.
Well, in theory we do, but the problem with that is that it prevents a lawyer from being candid about a past mistake, because instead of sitting there and saying, you know, on this case 3 or 4 years ago, I was occupied, I was doing something else, or I was sick, or I was doing something that I shouldn't have been doing, they can't come forward without jeopardizing their future employment anywhere in this field.
Certainly that is a major weakness with the court-appointed system. I have many friends that are very, very fine lawyers, that the primary source of their business is court appointments. And when someone comes to interview me to see if they want to retain me and I find that they have one of these lawyers, I try to discourage them from retaining me because I know they're in good hands and they haven't had to pay any money for it. I mean, that's a good deal for both sides there. But when you have a system where the lawyers are in any way indebted to the judiciary for the appointments, and the judiciary are indebted to the lawyers for the campaign contributions that enable the judges to be elected, you've got what appears to me to be a conflict of interest that's readily apparent.
Now, you say that, and yet that is the exact system we have in Texas.
Absolutely.
In other words,
and that's why I'm lobbying all the time for a public defender's office like we have in federal court.
Now, let's talk about that for 1 second. That doesn't remove appointments from the federal system.
No, certainly.
You and I have both accepted those.
If there's a conflict with the defender's office, then somebody has to step in, because you see, in the case of a conflict of interest, as we all know, a lawyer that's represented one person or one member of a drug conspiracy can't very well come in and then represent another person in the same conspiracy, or even a member that's in any way affiliated with that organization. And so, in all fairness to the accused, we have to have independent lawyers as well. But the quality of representation, I think, in the federal system, where there are no campaign contributions, is grossly different than we see on the state side.
Now, let's be honest too, though. A campaign contribution doesn't necessarily result in a quid pro quo. If that were true, every politician would be under some kind of suspicion if they simply accepted money to run. We have a partisan system here. Judges have to run for election. That's fair.
Right.
So what would you change?
I'd make a public defender's office. I wouldn't allow the judges to make, and let me say this, there's been great efforts made to make the system more fair. It used to be the case that certain judges, many of them aren't judges anymore, but would appoint the same lawyers over and over and over, and these were the lawyers that supported those judges. Ever since Senate Bill 7, we've had a change in that there's some sort of a system in place now where a group of lawyers are referred to that court and then they're assigned to cases. But I still find fault with that because within that method of assigning lawyers, there's still room for judicial discretion, and it creates that same sort of a feeling of conflict. Even if not an actual conflict, there's a feeling, a smell of something not quite right. And if there was an independent public defender's office with its own investigators, its own staff, just like the DA's office, with a budget equal to the DA's office, I think the quality of justice for the indigent accused would be greatly improved in Harris County.
Well, now, if you look at this from the other side, though, if you have a judge who knows the lawyers that appear before him or her, aren't they better able to match the case to the lawyer? One lawyer may be skilled and experienced in dealing with the mentally ill. One lawyer may have an accounting background and be a great candidate for fraud. a public defender system would prevent that kind of matching, wouldn't
Why?
it?
Why couldn't those decisions be made within the office of the public defender? The assignments could be made on the same basis. It's just purely from a defense perspective instead of from the judicial perspective.
But then the judge would essentially lose control of their court, wouldn't they?
No, not really, not at all. I mean, what you'd have is you'd have an autonomous prosecutor, an autonomous defense lawyer, and an autonomous judiciary. What a great idea. Sounds like a fair system to me.
Fair enough. When we talk about fairness, let's get to something that has been in the headlines recently, and this is the tragic breakdown of forensics in this county and across Texas.
The crime lab.
Let's talk about the crime lab, the big elephant in the room that nobody really wants to acknowledge.
All right, well, let me give you my spin on this. I recently published a law review article. I was asked to write an article about the crime lab, and I did. And I talked about all the problems with the crime lab, but in the article I pointed out this. The crime lab makes a very convenient scapegoat. And the reason I say that is because the crime lab's paper, you see, can be objectively graded. You can look at a chemist's work, and it's either right or it's wrong. But I think that some of the faults we attribute to our crime lab actually originate with our Court of Criminal Appeals and with our lawmakers, with our legislature, because the field of scientific evidence is very much controlled by the laws in effect that regulate what we regard as proper science. And for example, in the most commonly prosecuted felony cases, drug cases, there are two practices that are completely and widely accepted throughout the published cases and by the legislature. And one of them is random sampling, where if a group of baggies of a controlled substance, or a suspected controlled substance rather, I misspoke myself, is seized from a person, the law actually permits a chemist to only test some of the baggies, to only test some of the rocks of suspected crack cocaine, so long as they appear heterogeneous. Well, you can see what can happen here. In fact, it happened in Dallas. People were convicted of cocaine offenses for having sheetrock. This sort of lackadaisical attitude toward what is proper science by the legislature and by the Court of Criminal Appeals is certainly a major source of, if not wrongful convictions, at least grossly elevated punishments. I mean, a person can have some amount of cocaine that's actually cocaine and some other baggies of cut and yet be convicted as if all of it was cocaine, and no one will ever know the difference with random sampling. Another example, adulterants and dilutants. It used to be the case, and it's always been the case, that a person's not only responsible for the amount of controlled substance they're found to possess, but also the adulterants and dilutants, the cut that is found with it. It used to be the case that before something could be called an adulterant or dilutant, it had to be added with the intent to increase the bulk or quantity of the named substance. But the legislature did away with that because there were a series of reversals where prosecutors forgot to ask, well, what was the identity of the cut? Did it increase the bulk or quantity of the controlled substance? How much was there? And so to make the prosecutor's life easier, the legislature simply said, look, a controlled substance is anything, including the cut, anything found with it, and it's any substance plus the adulterants and dilutants that the accused is penalized for. So you get these folks that are drinking cough syrup that contains codeine in it and pouring it in a Mountain Dew or a Diet Coke to make it taste better. And the laboratory here in Harris County and across the state for that matter is weighing the entire weight of the soft drink plus the codeine-containing cough syrup, and we are putting people away in prison for really having an ounce of cough syrup, and we're making it seem as if they had pounds and pounds.
Taking something from a misdemeanor or state jail probation to a second-degree felony.
No, a first degree, 10 to life. Going from 6 months in the county jail is the maximum punishment, moving that up to 10 to life based on the presence of a soft drink and not requiring a quantitative analysis from our laboratory.
Now, here we get back to what we started out with, which is the anatomy of wrongful conviction. Okay? We've shown how this can happen through state misconduct, through bad lawyering on the defense side, through corrupt forensics, through a lot of things that lead you down a path that no one really wants to go down, but they wind up anyway.
We have a call?
We do? Let me take this. Hi, you're on Reasonable Doubt.
Thank you for taking my call. I'm not, anyone from the governor, like, what's his name? I don't have any time to comment on any of the other things. Interesting topic. Now we here are in Sutton plus 2, so let's talk about the ramifications. When innocent people are arrested, it's a crime against the individual's most basic of civil liberties. It's a crime against the victim for not receiving justice. And it's most likely a new crime that will be committed by the criminal that was free to commit it.
Well said.
I thank you for that, and we're going to talk right about that just now. Thank you for calling in. You know, that brings out one of the things that I think every good prosecutor and every good cop would agree with.
For every person wrongly convicted, there's a real crook walking free.
And that's got to bother them.
Yep,
that's got to bother them. So we're all on the same page. We want to avoid this. How do we fix it? And how do we fix it on the front end as well as the back end?
Well, I mean, I can micromanage this to death. I mean, I know all the little problems wrong with all these laws, but I think really what we need is to take a step back and look at the big picture and demand accuracy. Not be willing to say close enough for government work. Because when that's the message you send out at the highest levels of our government, that's the message the chemist in the crime lab hears. And even though the message is not, we're going to condone shoddy DNA. We don't care about your leaky ceiling dripping and cross-contaminating the samples. The message when you say random sampling is okay, the message when you say everything's an adulterant and dilutant, that's the message that the chemist hears when they go to analyze that sample of critical DNA.
So what you're saying is the standards have to be as high as they can be on the front end for
That's right.
everybody involved, defense, prosecution, state agencies, police, legal.
I would think that the presumption of innocence would call for nothing less.
Now on the back end, if something does occur, and as we both acknowledge, mistakes happen, how do you fix it?
Then we get to go into the post-conviction process of trying to undo the wrongful actions of whatever party was wrong in the given case. And it's a lengthy process. It's, in many cases, it's the only real trial the accused person ever gets. How do you fix it? I don't know. It's on a case-by-case basis. I mean, it's the most heartbreaking part of being a criminal defense lawyer.
For those of us who are not familiar with that, there aren't that many lawyers who do post-conviction fixing it process, in other words.
Yeah.
Folks, my guest tonight has been Norm Silverman, a well-known criminal defense lawyer here in Houston. I'm Pat McCann, filling in for Rob Fickman. You've been watching Reasonable Doubt, and as Rob likes to say, if you're ever called to jury service and you have a reasonable doubt, then your duty is to vote not guilty. Thanks for tuning in. We hope to see you next week at the same time, when we hope to have just as interesting a guest. Good night.